करेंगे एक ऐसे मुद्दे पर जो न केवल कानूनी दृष्टिकोण से महत्वपूर्ण है बल्कि भारत के संवैधानिक ढांचे और धार्मिक स्वतंत्रता के संदर्भ में भी अत्यंत महत्वपूर्ण है। हम बात कर रहे हैं वक्फ संशोधन अधिनियम 2025 पर सुप्रीम कोर्ट में 5 मई को होने वाली सुनवाई के बारे में। वक्फ अधिनियम 1995 के तहत मुस्लिम समुदाय द्वारा धार्मिक और धर्मार्थ उद्देश्यों के लिए दी गई संपत्तियों का प्रबंधन किया जाता है। हालांकि 2025 में इस अधिनियम में संशोधन करके वक्फ संशोधन अधिनियम 2025 लागू किया गया, जिसने कई महत्वपूर्ण बदलाव किए। वक्फ ट्रिब्यूनल के निर्णयों की अंतिमता समाप्त करना। अब वक्फ ट्रिब्यूनल के निर्णयों को उच्च न्यायालयों में चुनौती दी जा सकती है। वक्फ बाय यूजर की अवधारणा को समाप्त करना। जो संपत्तियां लंबे समय से वक्फ के रूप में उपयोग में थीं, लेकिन उनके पास कोई पंजीकृत दस्तावेज नहीं था, अब वक्फ संपत्तियां नहीं मानी जाएंगी। अब वक्फ संपत्ति नहीं मानी जाएगी। वक्फ बोर्डों में गैर मुस्लिम सदस्यों की नियुक्ति। केंद्रीय और राज्य वक्फ बोर्डों में गैर मुस्लिम सदस्यों की नियुक्ति की अनुमति दी गई है। वक्फ संपत्तियों के पंजीकरण के लिए केंद्रीय पोर्टल। सभी वक्फ संपत्तियों का पंजीकरण अब एक केंद्रीय पोर्टल के माध्यम से किया जाएगा, जिसे केंद्र सरकार नियंत्रित करेगी। वक्फ संशोधन अधिनियम 2025 के खिलाफ विभिन्न व्यक्तियों और संगठनों ने सुप्रीम कोर्ट में याचिकाएं दायर की हैं। इन याचिकाओं में प्रमुख आपत्तियां निम्नलिखित हैं। धार्मिक स्वतंत्रता का उल्लंघन। याचिकाकर्ताओं का तर्क है कि अधिनियम संविधान के अनुच्छेद 26 का उल्लंघन करता है, जो धार्मिक मामलों के प्रबंधन का अधिकार देता है। समानता के अधिकार का हनन। वक्फ ट्रिब्यूनल के निर्णयों की अंतिमता समाप्त करने से अन्य धार्मिक संस्थाओं की तुलना में वक्फ संस्थाओं के साथ भेदभाव होता है, जो अनुच्छेद 14 और 15 का उल्लंघन है। वक्फ बाय यूजर की समाप्ति। कई मस्जिदें और धार्मिक स्थल सदियों पुराने हैं, जिनके पास पंजीकृत दस्तावेज नहीं है। इस प्रावधान से इन स्थलों की कानूनी स्थिति पर प्रश्न चिन्ह लग जाता है। गैर मुस्लिम सदस्यों की नियुक्ति। वक्फ बोर्डों में गैर मुस्लिम सदस्यों की नियुक्ति से धार्मिक मामलों में बाहरी हस्तक्षेप की आशंका बढ़ जाती है। केंद्रीय पोर्टल के माध्यम से पंजीकरण। राज्य वक्फ बोर्डों की भूमिका को सीमित करके सभी पंजीकरण केंद्र सरकार के पोर्टल के माध्यम से करने से संघीय ढांचे का उल्लंघन होता है। सुप्रीम कोर्ट ने इस मामले में कई याचिकाओं को एक साथ सुनवाई के लिए स्वीकार किया है। हालांकि न्यायालय ने ये स्पष्ट किया है कि वो सैकड़ों याचिकाओं को नहीं सुन सकता, इसलिए न्यायालय ने पहले से लंबित 5 याचिकाओं को ही सुनवाई के लिए स्वीकार किया है और अन्य याचिकाकर्ताओं को सलाह दी है कि वो इन मामलों में हस्तक्षेप याचिका दायर करें। न्यायालय ने यह भी निर्देश दिया है कि यदि किसी याचिकाकर्ता के पास नए आधार हैं तो वो हस्तक्षेप याचिका के माध्यम से उन्हें प्रस्तुत कर सकते हैं। इन याचिकाओं पर 5 मई को अंतरिम आदेश पारित किए जाएंगे। केंद्र सरकार ने अदालत में एक हलफनामा दायर कर कहा है कि वक्फ संशोधन अधिनियम 2025 के खिलाफ दायर याचिकाएं भ्रामक और झूठे नैरेटिव पर आधारित हैं। सरकार ने यह भी स्पष्ट किया है कि जब तक अदालत में इस मुद्दे पर सुनवाई चल रही है, तब तक कोई वक्फ संपत्ति डी नोटिफाई नहीं की जाएगी और ना ही केंद्रीय राज्य वक्फ बोर्डों में किसी गैर मुस्लिम सदस्य की नियुक्ति की जाएगी। 5 मई 2025 को सुप्रीम कोर्ट में होने वाली सुनवाई इस मामले में एक महत्वपूर्ण मोड़ हो सकती है। न्यायालय इस दिन प्रारंभिक आपत्तियों और अंतरिम आदेशों पर विचार करेगा। यदि अदालत याचिकाकर्ताओं के पक्ष में अंतरिम राहत प्रदान करती है तो यह अधिनियम के कार्यान्वयन को रोक सकती है। इसके विपरीत यदि अदालत केंद्र सरकार के पक्ष में निर्णय देती है तो अधिनियम के प्रावधान लागू रहेंगे। वक्फ संशोधन अधिनियम 2025 के खिलाफ दायर याचिकाओं पर सुप्रीम कोर्ट की 5 मई की सुनवाई एक महत्वपूर्ण कानूनी प्रक्रिया है जो भारत में धार्मिक और धर्मार्थ संपत्तियों के प्रबंधन के संदर्भ में महत्वपूर्ण प्रभाव डाल सकती है। न्यायालय की ओर से याचिकाओं की संख्या को सीमित करना और हस्तक्षेप याचिकाओं के माध्यम से नए आधारों को प्रस्तुत करने की अनुमति देना इस मुद्दे पर एक संगठित और प्रभावी सुनवाई सुनिश्चित करने का प्रयास है।
Accordingly, the questions of law referred to are answered by stating that the court has limited power in Section 34 and 37 of the 1996 Act to modify the arbitral awards. This limited power may be exercised under the following circumstances. 1. Where the award is severable by severing the invalid portion from the valid portion of the award as held in Part 2 of our analysis. 2. By correcting any clerical, computational, typographical errors which appear erroneous on the face of the record as held in Part 4 and Part 5 of our analysis. Post-award interest may be modified to, in some circumstances as held in Part 9 of our analysis. And or Article 142 of the Constitution applies, albeit the power must be exercised with great care and caution and within the limits of constitutional power as outlined in Part 12 of our analysis. There's a slight difference of opinion between the majority and Justice Vishwanathan, and Justice Vishwanathan will read out that
this judgment approaches the issue by maintaining the conceptual distinction between modification and severance. Whenever modification is discussed, it is to examine whether a Section 34 court can change, vary, or qualify an award. Whenever severance is discussed, it has to be understood to mean to separate and disjoin. Parties have also canvassed arguments based on the distinction, while the rival parties were daggers drawn on the aspect of the power to modify in the Section 34 code. There was unanimity on the power to sever, subject to conditions compatible with severability. After discussing, setting out the arguments and the ecosystem of arbitration, particularly Section 5, the overarching note of restraint in judicial intervention as set out in Section 5, the proscription for intervention set out in Section 13.5 and 16.5, the range of options under Section 33 for the parties and the arbitrator to carry out repairs to the award in the manner set out therein, the limited option to seek recourse to set aside on prescribed grounds with the shackle within inverted commas only if in Section 34.2 and the further safety valve available in Section 34.4 to go back to the arbitrator under circumstances mentioned therein are clear pointers about the acutely circumscribed nature of the power in the Section 34 code. This viewed in the background of the fact that parties have with open eyes contracted to go for arbitration and subject themselves to the parameters prescribed in the Act after ousting the normal judicial process clearly indicate that parties were conscious of the limited role for the courts in the review of the arbitral awards. The absence of express powers to modify for a court hearing objections against the award when such a power existed in the Precursor Act also points to the legislative intent. It is in this background that the arguments of the parties clamoring for reading into of the power of modification needs to be tested. Thereafter, case laws have been discussed, arguments have been dealt with. The argument that absurdities will result and hardship will be caused if power to modify is not read into as no merit. There are at least two compelling reasons to hold so. The Arbitration and Conciliation Act in Section 43.4 itself contemplates that on the setting aside of the award, the option is to commence proceeding, including arbitration with respect to dispute. The lawmakers are fully conscious of the situation that setting aside of the award will result in the dispute continuing to be thrown open at large, since notwithstanding the setting aside of the award, the legal position is that the arbitration agreement survives except in situations where the order setting aside has findings impinging on the validity of the arbitration agreement itself. And hence, recommencement of proceedings, including arbitration proceedings wherever legally maintainable, being expressly contemplated in the statute, the same cannot be brushed aside on the grounds of causing hardship to the parties. Parties will no doubt have all contentions open. The second reason is equally compelling. As briefly discussed earlier, when parties agree to arbitrate, they consciously with open eyes agree to step out of the normal judicial process and submit their dispute to a third party. Parties then are also conscious that when they agree to arbitrate, their rights and liabilities will be governed by the regulating act, which is the Arbitration and Conciliation Act. In that sense, there is a contractual ouster subject to the terms of the Arbitration and Conciliation Act or the normal judicial process, and the said course of action is sanctified under Section 28 of the Contract Act. Thereafter, we have contrasted it with the appellate power of the Civil Procedure Code and how the powers are different. In view of this, Section 34 Court, unless expressly authorized by law, cannot modify or vary the award, since it will be tantamount to exercising the powers of a merits review when parties have contracted to have their disputes referred to a third party outside the normal judicial process for adjudication of arbitration. Then we have dealt with the various arguments about lesser power. We rejected all of them. We dealt with party autonomy, not reading all of them. From the reasons stated in the earlier part of the judgment, it is crystal clear that the court's exercising powers under 34, which will include the appellate hierarchy, cannot change, vary, or qualify arbitral awards, as it strikes at the very core and root of the ethos of the arbitration process. Such an excess of power will derogate from the core aspects of the Arbitration and Conciliation Act and will breach a preeminent prohibition in the Act. In view of this, my finding, which is the first point of difference, is hence, in matters arising out of Section 34 of the ANC Act, this court will refrain from exercising powers under Article 142 in view of the law laid down in SCBA and Shilpa Shailesh. I have also said that it will lead to uncertainties if such a power is reserved at the very end in the litigation process. The other aspect where I have disagreed with the opinion of the learned Chief Justice is on the power to interfere with the post-award interest. I have taken the view that the power option is to remit the matter under Section 34(4) to leave the arbitrator to do the correction. And I have also flagged the concern raised at the bar that it could result in complication in enforcement of awards internationally, because there is a conceptual distinction between enforcing a foreign judgment and enforcing an award. And I have since had the benefit of reading the judgment of the Honorable Chief Justice. In my judgment, I have independently given my reasons on each of the issues arising herein. The judgment of the Honorable Chief Justice grants power to the Section 34 Court to modify the post-award interest. I am not able to agree with the said view for the reasons stated herein above. Equally, the judgment of the Honorable Chief Justice permits the excess of power under Article 142 of the Constitution to modify the award, though it has been stated in the judgment that the power must be exercised with caution. Here again, I am not able to agree with the said view for the reasons stated in my judgment. Conclusion: the court exercising power under Section 34 and the courts hearing appeals thereunder have no power to modify an award. The power to modify is not a lesser power to that of the power to set aside, as the two operate in separate spheres and are not of the same genus. The inherent power under Section 151 CPC cannot be used to modify awards, as it will be contrary to the express powers mentioned in Section 34. Similarly, there is no scope for applying the doctrine of implied powers to modify the award. Article 142 of the Constitution will not be exercised by the court to modify awards passed by arbitrators, as it is well settled that the Article 142 power cannot be used to give a go-by to any substantive statutory provision. Interest awarded also cannot be modified in excess of powers of setting aside, and the course of action under 34(4) will have to be adopted as discussed in the judgment. Hakim Supra is not per imperium insofar as it held that Section 34 court cannot modify the award. It will be read with only the exception made in the judgment now. On the principle of actus curia nevenum gravavit, computation, clerical and typographical errors or other errors of similar nature is permissible to be corrected by the Section 34 Code. Kiranari Malik does not lay down the correct law insofar as it holds that the request under 34(4) to the court by a party to grant an opportunity to the arbitral tribunal to resume proceedings or to take such other action as to be in writing. Even an oral request under 34(4) can be entertained by the court. The power under 34(4) can be exercised by the court suo motu also under the circumstances set out here and above. A court under Section 34 and the court's hearing appeals thereafter have the power to sever parts of the award in excess of the powers of setting aside awards under 34. However, while severing, the parameters set out here and above and flowing from the judicial precedents discussed therein have to be followed. And answers to the reference have been given. Appreciation is recorded for the painstaking efforts put in by the learned Solicitor General and all the learned senior counsels who addressed arguments, and also to the teams assisting them. The reference is disposed of in the above terms.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।